There was a motion to add the laundry lawyer Steve Bertolino to the lawsuit filed by Gabby Petito's parents. Let's take a listen to what happened in court yesterday. And if you want the latest updates on this case, make sure to subscribe, follow this channel.
Counsel indicated generally an attorney is an agent for his client, and the acts of the agent are the acts of the principal. In a principal-agent situation, the principal is liable, in this case the Laundries, if the wrongful act is done while the agent, Mr. Bertolino, is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer or was not necessary or appropriate to serve the interest of the employer, unless the act was done to accomplish his own purposes as distinct from the employer's business. Again, we have to look at the face of the complaint. What does the face of the complaint say about what Mr. Bertolino was doing at the time he made the statement? Paragraph 8 says that at all times relevant to the cause of action, Stephen Bertolino was acting as the agent for Christopher Laundrie and Roberta Laundrie. Paragraph 28 states that Stephen Bertolino was acting on behalf of Christopher Laundrie and Roberta Laundrie when he issued the statement which is the substance of the claim for intentional infliction of emotional distress. We haven't alleged that he was acting outside of the scope of his authority when he made the statement. The complaint clearly states he was acting on behalf of the Laundries at the time he made the statement. So the principals are liable, the Laundries are liable in this instance, as is the agent, because an agent is individually liable to a third person for the agent's tortious conduct. And I cited the court to Sussman versus First Financial Title Company of Florida at 793 Southern 2nd 1066. I'd also like to cite the court to the third restatement of agency, section 701, which says, an agent is subject to liability to a third party harmed by the agent's tortious conduct. Unless an applicable statute provides otherwise, an actor remains subject to liability although the actor acts as an agent or an employee with actual or apparent authority or within the scope of employment. To suggest that the claim can only be made against the Laundries or on one hand, or against Mr. Bertolino on the other hand, is simply incorrect. It's entirely appropriate and it's entirely proper to set forth a claim against both of them under circumstances such as this.
Court file in total for this case, and as well specifically as Judge Carroll, as to Judge Carroll's order denying the defendant's motion to dismiss, and the instant motion, as well as defendant's response and plaintiff's reply to defendant's response. I've heard the arguments, and at this time I am going to be granting the motion for leave to amend. I find that the plaintiffs have not abused the privilege of amendment, that the amendment at this juncture is not futile, and there is no prejudice to the current defendants as to their preparation for trial or summary judgment. So I will be granting the motion for leave to amend.
There you have it. The judge granted the motion to add Steve Bertolino as a defendant in the lawsuit. What are your thoughts? Let me know down in the comments. And if you want to be updated on the latest on this case, make sure to subscribe and follow this channel.